Hey, folks. Yesterday, November 17th, was a pivotal day in the case of United States v. James Comey. On a motion to disclose grand jury materials, something that's been argued for a couple weeks now or so, Comey prevailed and prevailed in a very big way. The judge had lots to say after he reviewed the grand jury materials and proceedings. The judge arrived at a conclusion and made about 10 or so findings as to misconduct, misstatements of law, and violations of Comey's Sixth Amendment and Fifth Amendment rights, and possibly Fourth Amendment rights as well. It's ugly. It appears to be a very, very ugly situation for the DOJ and for U.S. Attorney Lindsay Halligan. And the judge ordered those grand jury materials, all of them, to be disclosed to Comey's team by 3 p.m. yesterday. But at 3 p.m., did that happen? No. Instead, U.S. Attorney Lindsay Halligan filed an emergency motion to stay the order, meaning pause it, don't enforce it. We want this reviewed by another judge. We think that Magistrate Judge Fitzpatrick erred in his ruling to disclose these materials to Comey. Her motion for an emergency stay wasn't all that compelling, I have to say. It was pretty weak. However, the motion in opposition that James Comey's team have filed, maybe they filed it about an hour or so later. It was very strong, but it offered a compromise which District Judge Nachmanoff took up. So the order is stayed for now. Comey doesn't yet have the grand jury materials, but he does have a big victory, and the momentum in this case, the story of this case, is very much in Comey's favor. And I think characterizing the case differently to that, I don't think it's a fair reading of the case. Now, if you've been following the case with me, reading my threads, watching my podcast, and the shorter form videos that I've been doing on Rumble and YouTube, then you weren't surprised by yesterday's development. We've been expecting it. We've been discussing the grand jury materials. We've been discussing the irregularities that were alleged about the grand jury. We've been discussing the privilege leaks and all sorts of pretty much every other issue going on in this case. And that's because we've been tracking the case since the day it was filed, document by document, filing by filing. We've been reading them together and extracting the tidbits of new information and analyzing the arguments in the filings and forecasting what was ahead. And what happened yesterday was something that we talked about was a very likely decision, if not inevitable, right? Thank you to everybody who has been tracking the case with me. If you would like to join us in tracking this case, we're having a good time. Because we pay attention to the day-to-day filings of the case, we tend not to overreact to anything that happens in it, because we're just tracking the story of it instead of peripherally picking up new crumbs of information about it from influencers and clickbait media. And it's a much more enjoyable way to follow a highly interesting criminal case that could have big impacts on other criminal cases that are currently going on and that have yet to be filed. If you go to the description of this video or in my profile, wherever you're watching or listening to this, you'll find my link tree. And on my link tree, you can find all the places to follow, watch, listen, and all the ways to support the show. Thank you to everybody who clicks my support links and contributes to my coffee fund and my Pacer fund. Really appreciate you guys. Now, in my most recent episode of my podcast, which is episode 354, it's available on justhuman.substack.com. Everything on my Substack is free. It's also available on YouTube, on Rumble, and on YouTube and Rumble, we have playlists for United States v. Comey, and it's available on my x.com account. I put all of my episodes in the highlights section. So if you just go to my profile and click on highlights, you'll see all my recent podcast episodes there. And if you click the show more button, you'll see the timestamps for when we discuss different aspects of the Comey case. Now, I do think my most recent episode is one of the best I've ever done, or at least in recent memory, it's one of the best. I covered 3 main topics in it. 1, the most recent updates in the Comey case. 2, newly disclosed emails from 2017 that show an FBI agent in the Washington field office trying to get an investigation into Hillary Clinton paying for the Steele dossier, trying to get that investigation started and being shut down by DOJ's Public Integrity Unit and the U.S. Attorney's Office of D.C. And then finally, in the last hour of that show, I do a for-your consideration, new perspective on the origin of Russiagate and maybe what Russiagate, Crossfire Hurricane, and everything going on with the Steele dossier was really about. And I don't think what it's really about is how media on the left or the right have long characterized it. But as pertains to the Comey case, and specifically what we're about to talk about in this video, if you go to about 55 minutes into that episode, I discuss the most recent filings in the Comey case, including new affidavits from U.S. Attorney Halligan and AG Bondi, her new order, and then new affidavits from the two FBI agents who were involved in this case. Actually, that part is at 29 minutes in, and then new filings clarifying grand jury proceedings are at 55 minutes in. So it's all within that first hour that I address this stuff. But if you missed that, don't worry, I'm going to brief you back up on it. I'm going to need a sip of my coffee. This video is probably going to go a bit longer than I would like it to because there's so much to talk about here. But like I said, yesterday was a super important day in this case, and it started off with a huge win for Comey. Magistrate Judge Fitzpatrick, once again, he's already made this determination and already issued this order before, finds that disclosure of grand jury materials is warranted in the case. He orders DOJ to turn over all grand jury materials to the defense by 3 p.m. today and all audio recordings by 5 p.m. What got us to this point is a bit complicated, but I have covered it in several threads and videos over the past few weeks. So I'm not surprised by this order, and I'm sure my followers who have watched those videos and read those threads aren't surprised at all either. If you want to avoid reactionary takes and understand what is going on in the United States v. Comey, I'm your guy. All right, here's what you need to know as background to what happened yesterday, and about as quickly as I can tell it to you. There's 3 judges involved in United States v. Comey. There's the Eastern District Judge, Judge Nachmanoff, and he's handling the criminal proceedings, the criminal case. He's handling all the filings that have to do with the pre-trial leading up to discovery, leading up to the trial, and then he's going to handle the trial himself. But there's 2 other judges. Magistrate Judge Fitzpatrick was brought in to handle the issue of a filter team. On October 13th, all Rule 16 discovery, which is discovery of evidence that the government has against you, had to be turned over in this case. That was Nachmanoff's order. On October 13th, DOJ had turned over about 85,000 pages of discovery to Comey's team. However, they had left out a small number or a small amount of discovery that was created during the Arctic Haze investigation. The Arctic Haze investigation happened 5 years ago or so. It was a media leak investigation, and Comey and Richmond were investigated, among others, for leaking classified information to the New York Times for an article, or information that wound up in an article. Magistrate Judge Fitzpatrick is handling that issue because it has to do with privileged communications. The reason that DOJ didn't turn over that evidence to Comey is because they realized there had been, and this is what it seems like based on filings in the case, there had been a screw up. Communications between Comey and Richmond, while Richmond, who is person 3 in the indictment, was retained by Comey as a personal attorney, were seized pursuant to 4 search warrants issued during Arctic Haze. It seems like this shouldn't have happened. And these privileged communications, which are covered by attorney-client privilege, were never filtered out of the rest of the evidence. And it looks very much like DOJ arrived at the moment on October 13th to turn over all of this discovery they had against Comey and realized they were in possession of attorney-client privilege communications that they should have dealt with before bringing the case. And so what they do on October 13th is they file a motion for a filter team. A filter team would consist of investigators and attorneys from outside of the investigative unit and the U.S. attorneys who are handling this case. And they would independently review that evidence, separate what may be attorney-client privileged from the stuff that isn't. The stuff that isn't could be turned over if the government intended to use it against Comey at trial. The stuff that is attorney-client privilege, the DOJ could then go to the judge and say, hey, we think that these communications, even though they're between an attorney and his client, we think there's a reason that it can be disclosed, such as the crime fraud exception. There are exceptions to attorney-client privilege. But they would have to go through that process in order to get a judge to sign off on DOJ being able to use those attorney-client privilege communications against the defendant. That is what the process that DOJ tried to start on the very day that this type of discovery was already due. To handle a matter like that, it's necessary often for the judge to bring in a third-party judge or someone outside the case for reasons of fairness and ethics, right? So he delegated that issue to Magistrate Judge Fitzpatrick. Magistrate Judge Fitzpatrick was delegated the authority to handle all proceedings related to the implementation of a filter team. 7 days after making that filing, asking for the filter date, well, actually it was a little less than 7 days, DOJ Halligan filed an expedite motion asking the judge to hurry up and grant this order. And the judge's like, I can't grant this order for a filter team. I haven't heard from the defense yet. And they have 14 days per the rules. Defense comes in and says, we're not necessarily opposed to the filter team, but we would like to challenge the underlying search warrants first because we believe that these communications should not have been seized in the first place. We think that there was a Fourth Amendment violation. So that makes things a little bit more complicated. So Fitzpatrick had been looking at this issue, and his first pass at looking at this issue was to say, yeah, it looks like there's some irregularities here and there should be disclosure. DOJ appealed that, said, no, we don't want to disclose this to Comey, and we don't think there's a basis to do so. There's a high bar for him to be able to break the secrecy of the grand jury proceedings, and he's not there yet. It goes back to Judge Nachmanoff. Judge Nachmanoff says, this is within Fitzpatrick's authority, and I'm remanding it back to him for further proceedings on the issue. We'll pick up with Fitzpatrick and what happened yesterday in just a moment, but there's another judge, a third judge that is involved in this case, Judge Curry. Judge Curry is the senior district judge from South Carolina. Now, the case is happening in the Eastern District of Virginia. However, Lindsay Halligan's appointment has been challenged. Both Comey, who Halligan indicted, and Letitia James, who Halligan also indicted, have filed motions to dismiss their indictments based on the unlawful appointment of Lindsay Halligan. I've covered that issue extensively, the filings having to do with that. I started off kind of thinking Halligan might not be lawfully appointed. That was where I was leaning. But DOJ's motion that she was very much compelled me that Halligan is lawfully appointed. Doesn't mean I think she's going to win on that issue. I'm not sure. But DOJ's filing on it was highly compelling and changed my mind. Senior District Judge Curry, it has been brought in because it's a rule that if the appointment of a U.S. attorney has been challenged by a defendant, an out-of-district judge has to hear that challenge. So Judge Curry is handling all the stuff that has to do with Halligan's appointment. In the process of doing that, and this is where we find out why it's important to bring her up, Judge Curry is reviewing Halligan's handling of the grand jury. And one of the reasons she's doing that is because Halligan was the only prosecutor to sign off on the indictment. And if Judge Curry rules that Lindsay Halligan is unlawfully appointed, then she didn't have the power to indict, which means the cases are thrown out. In other states where U.S. attorneys have been challenged and their appointments have been ruled unlawful for whatever reason, the indictments that they brought stood because other prosecutors had signed off on the indictment as well. Not so in the Eastern District of Virginia. So Judge Curry is also examining the same grand jury materials and proceedings that Judge Fitzpatrick is. They're both looking at some of the same things. And that means that DOJ is contending with or making filings to both judges about the grand jury materials, which are the materials that Comey's team is trying to get disclosed. Okay. It's important to understand that at this time, there are two distinct threats to this case. And both of those threats are being handled by Judge Fitzpatrick and Judge Curry. One threat is the irregularities with the grand jury process, specifically the grand jury potentially being exposed to attorney-client privileged information. Two, Halligan being the only prosecutor to present to the grand jury. If there was a spill of privilege, if information to the grand jury that they shouldn't have had because it was attorney-client privilege was conveyed to the grand jury anyway, that would be solid grounds for a dismissal of the case because it's a violation of Comey's rights. If Halligan is found to be unlawfully appointed, like other interim U.S. attorneys have been recently, that could be grounds for dismissal because she's the only person who signed the indictment. Now, DOJ was already ordered to turn over these grand jury materials back on November 5th, and I covered that in this thread back on November 6th, and I have a video about that specific issue. DOJ appealed, arguing the magistrate judge did not have the authority to issue the order. It got remanded by Judge Nachmanoff, and they made more filings. On November 10th, there were several filings leading up to the hearing that happened on that day. And that was when Fitzpatrick and Curry, they were both reviewing these grand jury proceedings. Today, Judge Fitzpatrick made his ruling, and he ordered that all the grand jury materials must be turned over to Comey. Now, what he found in his order is, like I said, ugly. The court finds the record in this case requires full disclosure of the grand jury material, and in so finding, the court recognizes this is an extraordinary remedy. But given the factually based challenges the defense has raised to the government's conduct and the prospect that government misconduct may have tainted the grand jury proceedings, disclosure of grand jury materials under these unique circumstances is necessary to fully protect the rights of the accused. In the filing what I'm going to do is give you some of the highlights of what they found, okay? Or what Judge Fitzpatrick found was in the grand jury proceedings. He found that the 4 search warrants that were used against Richmond didn't cover the type of information that now the government is seeking to use to indict Comey. The 4 search warrants were before 2 other types of crimes, and they were limited in scope. And yet it appears that DOJ seized information that was outside the scope of those search warrants and now is seeking to use that information against Comey. That's why Comey says we want to challenge the underlying search warrants. The government never has engaged Comey in the process to review this stuff for the filtering the information, even though they know that Comey retained Richmond as an attorney on May 9th of 2017, the day he was fired. And they know that because they were informed of it by Richmond in writing. And yet they had 5 years to go through this material. They had 5 years to use a filter team. They had 5 years to bring Comey in to assert his privilege and then go through this process, and they hadn't done it. Arctic's investigators collected information from Richmond's iCloud account that was well outside the scope of the warrant and was well past the date on which Richmond was retained as Mr. Comey's attorney. There's possible Fourth Amendment violations here because the search warrants were for evidence of specific crimes. Those crimes were theft and conversion of stolen government property and unlawful gathering or transmission of national defense information. That's not what Comey's charged with here. Comey's charged with false statements and obstruction. when the judge asked the prosecutors about this, they simply did not know. They simply did not know. And to be fair to them, that's not surprising because the prosecutors who are on this case didn't investigate Articades. They weren't part of that team. And they didn't really investigate Comey at all in the lead up to the indictment. Lindsay Halligan added the two prosecutors on this case after Comey was already indicted. She brought them in from North Carolina and then handed them this thing. It looks like she saddled them with a very problematic case. This failure by the government is even more concerning because one warrant specifically directed the law enforcement officers to review and identify information in it that was responsive and to seal any information that was not, did not fall in the scope of the warrant. It gets worse. Inexplicably, the government did not elect to create a new search warrant in 2025 when they were investigating Comey. They could have done that. They did not. Instead, they used other information, open source reporting, open source information, the Comey's testimony, and then they went back to this Arctic Haze stuff and extracted from it things that they thought would help them in their case now, but they stepped out of bounds in doing so. And it does appear that they chose expediency to get the case forward and indict Comey just 5 days before the statute of limitations expired on the charge. They chose expediency over careful investigative steps. If they had gone about this in the correct and careful way, they would not be in this situation. Hence, on the very day discovery was due, suddenly filing a motion for a filter team. That should have been a filter team that should have existed 5 years ago, folks. Now it just keeps getting worse. Probably because they didn't go about this the right way, the investigative team here made some serious missteps. The lead FBI agent on the case was exposed to attorney-client privileged information, something that never should have happened. He then, shortly after being exposed to that information, which he should not have known about, served as the only witness to the grand jury. After testifying to the grand jury, the Office of Legal Counsel at the FBI pulled him off the case because he had been exposed and was now aware of information he should not legally have been aware of. And there's reason to believe that he conveyed at least a characterization of that information he was exposed to the grand jury, which means information that the grand jury shouldn't have had informed their decision to indict, at least potentially. Let me scroll down to some more highlights. There's so many here. The government substantially relied on statements involving Comey and Richmond in support of their proposed indictment here. And while there isn't specific regurgitation of those privileged communications to the grand jury, it doesn't appear that way. In testifying to the grand jury, both Halligan and the lead case agent referred to those statements in responses to multiple questions from the prosecutor and the grand jurors. So they still used that information. The government's position that privileged information, this is the quote, the government's position that privileged materials were not directly shared with the grand jurors ignores the equally unacceptable prospect that privileged materials were used to shape the government's presentation and therefore improperly inform the grand jurors' deliberations. And now it's going to get even worse. The court has identified, meaning Judge Fitzpatrick, in reviewing the transcript, audio recording, and all the materials at the grand jury proceeding, the court has identified two statements by the prosecutor to the grand jurors that on their face appear to be fundamental misstatements of the law and could compromise the integrity of the grand jury process. What she said is redacted. We don't know exactly what she said, but it's characterized by what the Fitzgerald wrote here. It seems like after first having advised the grand jurors that the prosecutor was their legal advisor, okay, that I'm going to instruct you on the law. U.S. Attorney Halligan tells them, I'm going to instruct you on the law. She then made a statement, which is redacted. And the prosecutor's statement that redacted, whatever she said there, is a fundamental and highly prejudicial statement or misstatement of the law that suggests the grand jury. It's actually, let me reread this. It's hard because of the redacted portion. Halligan's statement that redacted is a fundamental and highly prejudicial misstatement of the law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. Huge error. The prosecutor's misstatement ignores the foundational rule of law that if Comey exercised his right not to testify to the jury, that they could draw no negative inference from that decision. The prosecutor's statement that redacted may have reasonably set an expectation in the minds of the grand jurors that rather than the government bear the burden to prove Mr. Comey's guilt beyond a reasonable doubt at trial, the burden shifts to Mr. Comey to explain away the government's evidence. Second, the prosecutor told the grand jury that there was redacted. That statement clearly suggests to the grand jury that they did not have to rely only on the record before them to determine probable cause that could be assured the government had more evidence, perhaps better evidence, that would be presented at trial. Not good. And then it gets even worse. There were 2 indictments issued here. The first was a 3-count indictment, and the jury failed to return that indictment. It didn't pass. They didn't have enough votes to push that 3-count indictment for it. It failed. It's called a no true bill. But the 2-count indictment, which is the second one that was supposedly presented to the grand jury, did get a vote. It got 14 votes to bring the case forward. But there's an issue with this process. The second indictment was a new indictment, and therefore the undersigned concluded after reviewing the grand jury transcript, I mean, the judge looked at this, he concluded after reviewing the grand jury transcript that the prosecutor would have presented the second indictment to the grand jury for consideration before it was returned in open court, but it now appears that may not have happened. The short time span between the moment the prosecutor learned that the grand jury rejected 1 count in the original 3-count indictment and the time the prosecutor appeared in court to return the second indictment could not have been sufficient to draft the second indictment, sign the second indictment, present it to the grand jury, provide legal instruction to the grand jury, and give them an opportunity to deliberate and render a decision on the new indictment. So it looks like she took the 3-count indictment. It returned a no true bill. It doesn't pass. And it looks like what she did was remove one of the counts that was the problematic one for the grand jury, and then either have them just vote again without representing the indictment, or something screwy happened. And if this procedure, if this did not go down the way that is very strictly controlled and prescribed to go down in the grand jury process, if the grand jury process was not followed, then the judge here is in uncharted legal territory, in that the indictment returned in open court was not the same as the charging document presented to and deliberated upon by the grand jury. When prosecutorial misconduct before the grand jury prejudices a defendant and threatens the defendant's right to fundamental fairness in the criminal process, a district court may exercise its supervisory authority to dismiss that indictment. Here, the procedural and substantive irregularities that occurred before the grand jury and the manner in which evidence presented to the grand jury was collected and used may rise to the level of government misconduct, resulting in prejudice to Mr. Comey. The judge then came up with 10 findings. Actually, it's 11 findings. That's a typo. 11 findings and a conclusion about this case, or about what he had looked here. First, the facts establish a reasonable basis for the defense to challenge whether the Richmond warrants were executed in a manner consistent with his Fourth Amendment rights and consistent with the orders of the court that issued those search warrants. Second, the facts establish a reasonable basis for the defense to challenge whether the government exceeded the scope of the Richmond warrants. Third, the facts establish a reasonable basis for the defense to challenge whether the government had the lawful authority to search the Richmond materials. Fourth, the facts establish a reasonable basis for the defense to challenge whether the government's 2025 seizure of Richmond's materials included information beyond the scope of the original warrants. Fifth, the nature and circumstances surrounding the government's potential violations of the Fourth Amendment and court orders establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard for the law. Sixth, the facts provide a reasonable basis for the defense to show that they were prejudiced by the government's use of the Richmond materials in the grand jury. Seventh, the facts establish a reasonable basis for the defense to challenge whether the government took sufficient steps to avoid the collection and review of privileged materials, including the reason why Comey was never afforded the opportunity to assert a privilege over those communications until after there was an indictment. Eighth, the facts establish a reasonable basis for the defense to challenge whether privileged information was used directly or indirectly by the government to prepare and present to the grand jury. Ninth, the nature and circumstances surrounding the disclosure of potentially privileged information establish a reasonable basis to question whether the government's conduct was willful or in reckless disregard of the law. 10th, as discussed in section 4 of the memo here, above the prosecutor made statements to the grand jurors that could reasonably form the basis for the defense to challenge whether the grand jury proceedings were infected with constitutional error. 11th, the grand jury transcript and recording likely do not reflect the full proceedings because, although it is clear that a second indictment was prepared and presented to the grand jury, the transcript and audio recording of the proceedings do not reflect any further communications after the grand jury began deliberating. And if you were with me for a previous video where we went through filings to Judge Curry about grand jury proceedings and how the grand jury went down because Judge Curry had said at a hearing last week that it looks like some of the minutes are missing because the grand jury meets from like 2:30 to 4:30. And then there's 2 hours of nothing. And then at 6:40, suddenly there's an indictment and the process and they go and file the indictment. Actually, they filed both of them, right? The one that failed and the one that passed. But there's a 2-hour gap where there's nothing on the transcripts. In her motion, it was a clarification motion or clarification notice to Judge Curry. Lindsay Halligan said that 2-hour gap is when the grand jury deliberated. But that indicates that there was the one 2-hour presentation and then the one 2 hours of deliberation. And yet we have a failed grand jury indictment and a passed one. How can there be those two things out of only one presentation and one period of deliberation? It should be present, deliberate, fail, and then present, deliberate, pass. Collectively, the facts set forth herein and the particularized findings of the court establish that grounds may exist to dismiss the indictment because of matters that occurred before the grand jury. Therefore, Judge Fitzgerald found that, the grand jury material should be disclosed to Comey's team, and they can go through it, and then they can file their motion to dismiss if they want to, based on those. Now, immediately after this, hours later, emergency motion to stay was filed, and as I told you earlier, the judge went ahead and agreed on that, but on a very expedited timeline, and it would appear that he agreed to it because Comey's team said they would agree to it. Messed up my the thread jumped back to the top. Comey's team at the end of their oppositional filing said this: to the extent that the court is inclined to grant a stay, the defense requests an expedited briefing schedule, and that would basically be, let's handle this week. Prosecution wanted to have until November 24th to file their first brief on this, their first objection. What the judge ended up ordering, he said it's granted in part. He granted DOJ's motion to stay in part. And the in part aspect to this is that he basically granted the order to stay, but he also granted defense's schedule plus about 24 hours. So Wednesday, the government has to file their objections. Comey's team has to respond by Friday of this week, and then Judge Nachmanoff is going to handle it. So, big win for Comey. Actually, I would say a huge win for Comey. And this is a ugly, ugly mess for DOJ to sort out. Maybe they can. Maybe they can, guys. Maybe Halligan's team, they've got an explanation for every one of the findings that Judge Fitzgerald has here, right? Maybe they do. And they can explain every little thing. They can articulate how Fitzgerald misunderstood the process, misunderstood what Halligan said, all of that. Maybe they can, but I doubt it. And if they can't, well, I think the judge is going to find that there's enough of a basis here to turn disclose these materials to Comey, no matter what. I think the judge is going to find that there's enough irregularities here. There's enough reasonable basis and particularized evidence to justify breaking grand jury secrecy and disclosing all the materials to Comey's team for them to go through and see if they can construct motions to dismiss one or more out of the grand jury materials. So this isn't going away. But the explanation for all of these irregularities and this apparent misconduct and misstatements of the law and privilege spill and all of these things, maybe there's a really good explanation or series of explanations that Halligan's going to come up with. And this case will survive this challenge. However, it is not looking good for DOJ here. It's not looking good for Halligan. If you're interested in this case, I'm keeping track of it filing by filing. Thank you for joining me. Hit like, subscribe. Let me know in the comments what you think about the status of this case, what position it's in, what position each side is in, whether you think the case against Comey is going to survive a disclosure of grand jury materials, whether you think Halligan's going to get dismissed as the U.S. attorney. I'm interested to know your thoughts on this case. All right, I'm going to go record more videos about more developments in the case, and I'll see you on the next one.